disclosure. We were talking about disclosure in the research, innovation, and commercialization process. And our facilitator, who was also a facilitator on Tuesday, is Josiah Kwesi Asen, the CEO of iSpace Foundation. A certified investment readiness trainer, is certified in leadership and management. Without further ado, let's welcome Josiah Kwesi Asen to take us through the disclosure in the research, innovation, and commercialization process. I would love it if you send some, I don't know, some thumbs up in the chat, just as a welcome to him. So with a round of applause from me and some thumbs up, let's welcome him on board. Thank you.
Thank you, Olivia. That makes me feel like a superstar, if I'm on stage, but yeah, thank you. Can you hear me clearly?
Yes, we can hear you.
Okay, great.
Yes,
so good afternoon, everyone. And sincere apologies for yesterday. It was a flight issue, so I wasn't able to make it on time. So thank you for allowing this session to be pushed to today and also spending the time this afternoon for this session. So last, on Thursday, we looked at the first stage in the commercialization cycle, which was or is research or / innovation, depending on where you are. And today we're going to look at disclosure, right? And when we talk about disclosure, again, this is one of the most fundamental part because it deals with the IP, right? And the innovations and stuff that you have that kind of makes you more or gives you that competitive advantage that you have, right? And a lot of us create products and we just either just put it out, we don't own any IP to it. So technically, in a nutshell, you don't own it just because you have the logos and everything else, just that. But then when you look at the ingredients and everything else that goes into making of that secret sauce and everything that you own, unless you have that intellectual property, you don't own it. So this is what disclosure is trying to aim at, and it will tell you all the various strategies that you can use in order for you to do that. And after that, we can have questions and answers. So it's saying that this is one of the critical stages in the whole commercialization stage, because then it allows you to then talk about your particular innovation. This is where you put it out and then hopefully make money out of it, right? And there are key stages, but the ones that we're going to focus on will be the 6. But out of the 6, the one that we really focus on will be the first one. So you look at protecting your intellectual property, right? And then non-disclosure agreements that you need to have, your licensing, your agreements, your publishing, research, whether you have an international rights to even sell those products internationally, do you have that, right? And then how do you go about making it public and then the timing of it? So this is the kind of look that we're going to have today based on the questions and answers that we're going to travel to. But the one that we're going to really focus on will be the intellectual property. So naturally, the question will always be, what do we mean when we talk about intellectual property, right? And it's saying that this refers to your legal and then strategic measures that you take in order for you to protect or safeguard those assets that you have, right? So your creativity, your drawings, your logos, everything that you need to ensure that you protect, those trade secrets that you have. How are you mixing your product, particularly if you're into cosmetics and everything else? If you're working with people, how do you ensure that they don't go off and tell others about what it is that you have in your product, right? Do you own that? Do you even own it to begin with? Because then again, if you don't own it, then you can't really sue somebody if they go out and talk about it. So today we just focus on that intellectual property. And to protect it can take so many different formats before you go to the legal side of things. So a few of the strategies here would be naturally copyright. Now, copyright it cuts across so many phases in that regard. So again, when you look at, do you own the images that you're using? If you paid for your studio time and then you posted those pictures online and somebody went and used those pictures, you can come on Facebook and cry all you want. Somebody used my pictures, or in Ghana, people just take people's pictures. Well, yes, because they are publicly available. You didn't put any watermarks on it. You didn't do anything. Do you own the copyright to use it? Anybody can use it, because then they can use that to reproduce any image that they want. So you have to think about the copyrights to the image that you're using, or even your logo, because we've heard instances where people literally put their product in somebody else's packaging and then sell, they'll go ahead and sell it. You can be upset again, but do you own the rights to it, right? And then when you look at the patent, certain innovations that you have in your product and design and everything else, do you own them? You don't own them. So if you don't own them, that means that anybody can use it. And as you can see, it says if you protect it, it usually would last you about 20 years, right? Your copyright, if you own the copyright, that can last for about 70 years. See, so in 70 years, somebody cannot use your images, they can't use your ideas or whatever. And if they do use it, you still own those rights for 70 years. So you can literally sign off those rights to your great-grandchildren or whatever, and they can make money off it, right? See, so copywriting is very important. And then having a patent as well is also important, because innovations without patents cannot work. And typical example of that is when you look at the Apple phone now, they've been forced to use the Type-C, right? Now, which product or manufacturer had a Type-C before Apple? That was Samsung. But then, obviously, before it came out, or Samsung using it, they had the rights to use it for a long period of time before Apple are now being forced into using it, right? See, so it wasn't a case of the moment it came out, then boom, Apple started using it. They cannot use it until whoever owns that patent says that, yes, you can use it. So this is something that you need to also think about when you think about your copyright. When you think about your intellectual property, do you own more than just the copyright, but then the patents to it, different designs and everything else that comes with it? Can somebody use it? And if they're going to use it, what can you do and how long do you own it for? And then when you look at things like your trademarks, again, it clearly states out formulas. So we're talking about those of you that are doing anything to do with cosmetics. Again, the formulas that you're using, that's your trademark. Do you have the rights to it? How are you keeping that information secret? Because it's valuable to your business. If somebody then has it, then again, they can just replicate your product and then speak to a third-party customers, as I call it, because this is not the ones that you're targeting. They will take your product, package it, and then go and sell it somewhere else, right? Do you own that? So this makes sure that once you have the trademarks to it, it protects you. Nobody can use it. If they use it, you can sue them. And that's something that you have to think about. Again, a lot of you are creating products and services put on the market without any thought process when it comes to either owning the copyright or trademarks to any of these things. And that's something that you need to also look at. Now, when you think about the whole geographical side of things, mainly, here's the thing. We think about Champagne, for example, in a region in France, south of France, I think, that name comes from. So if you have a bottle that says Champagne, then automatically that assumption, and again, it's assuming that it's coming from there. Hence why you see a lot of drinks that are Champagne can't call themselves Champagne, because they don't come from that region. If they came from that region, they can use the name. So typical example, again, if you share butter, if let's say the whole of the North decided to call one region in the North share butter, right? They can copyright that and own the intellectual property that any share butter that doesn't come from that particular location should not be called share butter. They can call it something else that says, yes, it feels like shea butter, but it's not called shea butter. See, so you can actually, a whole village can own a copyright in that essence, because that's where it comes from. Because right now, anytime we think about shea butter, we think about the North, right? See, so once we think about the North, why don't they own the copyright? So then they then make sure that unless it's coming from this particular area, do not call it, what do you call it? Share butter. Why is that important? Because it adds a bit of competitive advantage to it. You make sure it's authentic, it's credible. So those are the things that you have to also think about. So again, if you're smart enough, depending on the product or service that you're using, you can look at ways in which you can lock in the intellectual property for the area or the geography that you're from, right? And then, so after you think about it, these are types. So you're moving on from copyright, utility models that you can have, then the geographical side, the patents, the trademarks, industrial designs. These are some of them, not all of them, but these are some of them. And after you've figured out which ones you want to do right now and move towards that based on the budgets and everything that you have, these are some of the strategies that you have to look at, right? Now, again, contracts are very, very important. Now, when we get to the questions and answers part, I'm going to ask a lot of you, how many of you actually have contracts that you sign with your employees, right? Do you sign contracts, NDAs, with your employees, confidentiality agreements and stuff with your employees that says that you work for me between this year or this period of time. After you leave, you can't work for another similar organization for the next 6 months. If somebody cannot sign that, you should not employ them. Why is that important? Mainly because if somebody takes or understands how you particularly create a product and then they leave within less than a day or two, they're working for your competitor. You don't want that. But at least if you put those 6 months clause or a year clause in it, that ensures that regardless what happens for that 6 months, you've got a breathing space. And if they then break that contract, you can take them to court. You can also use that with your people that you collaborate with, right? Partners and all of these other things. You can sign contracts with them to ensure, right, that they do not go and disclose your trade secrets with anybody, right? Then registration. So this is where you file for your patents, your trademark, your copyrights, and any other thing that has anything to do with the business that you do, right? Normally you do it with government agencies that would then allow you to have the ownership to it and exclusive rights to it. And another, again, an example of exclusive right, which recently changed, is the FIFA game, right? EA Sports, the design FIFA game, had to use the name FIFA on it because it had something to do with football and this, the players that were being seen or used on screen. So FIFA had the name. It's only, I think it was yesterday, that another company has then ensured that they've bought rights to not use the FIFA name anymore. So they've totally canned the FIFA name and created a new name, right? So at that moment of time, they had exclusive right to use the FIFA name. So if anybody wanted to use the FIFA name, they can't use it, or they have to pay them for that, right? So there are so many other ways in which you can do that. So you register and then ensure that you own the exclusive right. Nobody else can use it. You see that a lot in franchising. KFC, they have the exclusive right to sell that brand or that particular taste of chicken in certain areas. Nobody else can do it. Burger King does exactly the same thing. Rumor has it, depending on who you believe, you have Burger King and you have McDonald's, but for some reason, Burger and McDonald's cannot come into the West African space, right? And again, it depends on who you believe or not, because they've got exclusive rights to be the only people to be here for a period of time before the likes of these other agencies start coming in. So you can buy exclusive rights for a particular area or product for a period of time before somebody else then comes in, right? Then we look at strategies that you can use, so monitoring and enforcing, right? So regularly checking online, regularly ensuring that your partners know who owns the IP. You need to go onto the market to ensure that people are not using your product or your logo or any form of imagery that has anything to do with your company on the market without you knowing about it. So you have to go online. You have to go to Mokola, you have to go to all these other various vendors that sell similar things to what it is that you do, right? Now, if you sell oils and stuff, for example, and let's say you have peppermint and lime in it. I don't know why you have peppermint and lime in your oils, but I'm just saying for argument's sake. You then go to another store that is doing peppermint and lime, the same variant and everything that you're doing. You can't technically be upset, but if you smell it and it smells exactly like yours, you need to ask questions, because how you mix it will determine how the smell and everything else that you added to it will determine. So you need to monitor, and you do this by going into the stores, again, looking at what your competitors are doing, tasting their products or testing their products, having a feel for their products, then to ensure that everything else is running. So that's something that you have to do on a regular basis, right? And then when you look on the global stage, can you even get global protection for your IP, right? And a lot of companies do this. So like Marvel, and so companies that have huge budgets can do this. If you don't have a huge budget, just focus on the local side of things first. Then you think about other regions and everything else, so you can have a global protection for your brand, particularly those African brands that you have now that are trying to move into Europe and all of those other things. Trust me, your copyright only lasts from the shores that you have. A bit like the way we make jokes around, let's say, African juju only stops at the borders of Africa, no, whatever, shores that you have. Don't let your IP protection be exactly the same. Literally, you have to look at different locations, right? So the strategy around it is looking at organizations that can enable you to have that agreement on a global scales. Because again, you trade in the global market, you want to ensure that nobody else in the global space or outside your region can easily take your product and do what it is that they want to do with it. See, so you have to think about these things, right? And then you look at your evaluation, right? Evaluating the value of IP assets from licensing it, the sales, or the financial purposes that you have. So again, if I license and I'm using KMC again, if I... Then...
So you have to ask,
somebody needs to mute their mic. I just got my heart jumped with it. But yeah, thank you. So yeah, when you look at evaluating your IP, again, the assets that you need to license to people can use your brand, they can use your image to then move into a different market. That adds value to your IP. See, so if you're in Ghana, but then another company in Kenya then uses your brand to then go into the market. So basically you are not there, but they're using your brand as an entry to their market. That's another way where you add value to your IP, because then if somebody's using it somewhere, it's registered, it adds more value to you. So those are the things that you also have to think about. You don't necessarily have to go into those market, by force. You don't have to. You have to ensure that you can partner with somebody that is in the market, and then you sell your IP to them, right? So your intellectual property and everything else, they can use it. You make money at the back end, and everything else is cool, right? So these are some of the strategies that you can use to make sure that you add value to your IP. Then we talk about the tools that you can use, right? Because again, to disclose something, there has to be tools. But here's the thing. Disclosure depends on the level at which you are. You have the public declaration where you have to declare your product, again, for everybody to see. Then you have the internal. So the two versions of it. You have the external disclosure, and then you have your internal disclosure, right? Now, the internal disclosure is what I'm looking at right now, and then I'll talk about external. The internal is when you talk about your team, or you talking to potential investors, you talking to potential partners or collaborators and all of those other stuff, right? Because you need to disclose certain things that you're doing to them. So how do you go about this? So you look at virtual rooms. Virtual rooms are basically secured online, platforms that are designed to share sensitive information, right? Sensitive information. Now, these things, they help you. How do they help you? So you can use, Data Site One, Femex, right? Merrill, all of these places you can use as virtual deal rooms because they have timestamps on them. If you're a musician, one of the things that we used to advise musicians back in the day, but now you can do it because when you put your music on the software, it records the timelines and everything else. But back in the day where you would send a demo to somebody, you put it in an envelope, you seal it, you send it to yourself so that you don't open it. And the time in which it was sent will determine whether you own the music or not. But right now you have deal rooms. So those deal rooms are also working as if it's like a post office, right? So you meet there with your potential partners and collaborators. This is where you talk about sharing your sensitive information about your particular product or service that you have. Then you have online collaboration tools. So the usual ones that would be the Slack, the Microsoft Teams, you can use Google Docs. All of these things are spaces that you can use as collaborative tools that you can use, right? Now, it's important because once you bring in other people, it tracks, and then it keeps in the back end who that particular email or tools or information or document was shared with, and when they open it, and everything else is there. This means that the person cannot go out and then say that it is their idea when you can trace back the timestamp and say, hold on, I have it on record that I shared it with you on X amount of days. You were even commenting on it, and this is what you said, right? Because the Google Docs of this world tracks all of these things. Slack tracks all of these things. So you have to think about it. So if you don't have that much money, use the collaborative tools such as Slack, Microsoft Teams, use Google Docs, use Dropbox, all of these things, right? Even to the point where there's this thing called smart contract that you can use. It's a blockchain for IP protection, right? But yeah, those of you that are into blockchain, this is something that you also need to look at. So it's called smart contract. Look it up. It enables you to have timestamps. So when documents were shared amongst people, who shared it, what was commented on it, it keeps track of all of those things. So that's something that you need to look at. And then again, secure document sharing platforms, like we talked about, formerly G Suite, but then it's Workspace now. You're looking at Microsoft SharePoint, you're looking at Dropbox, as I spoke earlier. They allow you to share documents with people without them necessarily changing the document. So you can even, in the past, people would have said use PDF, but now that you can easily rip off PDF, I wouldn't say it's advisable, but use platforms that it would make it harder for people, because once you log in, I know when you log in, because you need to log in in order for you to take the document. So just like Dropbox works, I create a folder, I share the link with you, then you create the password and you go in it. So that way I will then know, right, who went in it, by whom, and all of those other things. So it helps you. So you can share images, you can share videos, all of those things are easily tracked when you use platforms that are secure in that regard. And then obviously we look at watermarking. So watermarking is basically the image that you put onto another image, right? So if you take a picture, you can put a small watermark on it so that basically people can never use it again. There's so many tools that you can use for that. And happy to discuss all of these things with what tools to use for these things. If you're interested, reach out and then we'll talk about it. Now, the next important thing that you have to think about is your disclosure form, right? Now, why do you need a disclosure form? Because this is what you're going to use for your patents, right? Now, a disclosure form, also known as an invention disclosure form or technology form. This is a formal document used by organizations, used by universities, used by research institutions and businesses that enables them to capture and record information about their new invention, discovery, innovation, service, product, whatever the case may be, right? This form is typically use, right, to initiate the process of evaluating and protecting and potentially commercializing that intellectual property associated with innovation. So this form is important. Now, with this form, I mean, you can create it, right? But the organizations, the next slide will tell you organizations that you can reach out to, that you can talk to, and they have forms. So this form should naturally have the title of the innovation itself. What is the title of the innovation? So what is your product called, right? You need to have it. The inventor's names and contact details. So any and everybody that is involved in the development of that particular product or service, their name needs to be on the form, right? Why is this important? Because we don't want somebody sitting somewhere and saying that, oh, I created a product, but they didn't put my name down. It creates a problem for investors because nobody wants to invest in you when people are suing you, right? Let me repeat, nobody is interested in investing in you when everybody is trying to sue you, right? So bear that in mind. So you need to have the innovator's name and your contact information, everything on it. There's significant dates. When you started, what have you done? What did you do at this particular time? All of those things are things that needs to be done. So if you went on a meeting with Mr. X, you need to put it away on this day. We went a meeting with Mr. X, and probably to the point of what was discussed at that particular meeting. Then you talk about description of the invention. You need to describe it. Again, is it a platform? Is it a platform? What does it do? What kind of platform is it? It's a mobile app. What platform was it built on? Is it an Android? Is it an iOS? What? Give us a description, what it does, and everything else we want to know, right? And then prior artwork that you have. So again, the artwork that you might have right now, or the mock-ups and stuff that you have right now, are not necessarily what you started with. See, so we need to have all the prototype drawings that you had in the past. You need to be able to file all of that. Why? Because if you don't file them and then somebody else sees the beginning artwork that you had, but funny enough, that beginning concept was actually nicer and they can make money out of it, they will just go and file that part as theirs, and there's nothing you can do about it, right? There's absolutely nothing you can do about it. So let us have all the previous artwork that you've done on that particular idea, concept or whatever, so that we will know that you own everything. And then we talk about public disclosures of invention and commercial activity. Now, public disclosures, those of you here that like pitching a lot, right? You need to put down if you pitched, when did you pitch? Publicly disclosed it. You let people know that this is what you were doing. Any commercial activity that you had, if you're selling your product before you got the intellectual property to it, we need to know, right? We really need to know that you actually already selling your product A, B, C, and D. You sold X amount at between what time and everything else. We need to know the commercial activities that you've taken. And then funding resources. Where did you get your money from, or where are you getting your money from? If it's from your grandmother, from your father, your auntie, whoever, you need to put it down that, yes, this is where it comes from. This is how much we raised, and everything to date, this is what our funding sources are. And then we need witnesses, right? We need people that will verify that what it is that you're saying is true. So we need witnesses. And please don't let it be your mother, right? Or your girlfriend, or even your wife, right? Don't let it be your best buddy. Let it be credible people. Let it be people that have, they're stakeholders. So in that case, they're credible people. It could be a lawyer, it could be a doctor, it could be a teacher. Make it so that the people that you're getting to be witnesses for you are very credible people. So when you talk about submitting this form, so a completed form is typically submitted to organizations that look at technology transfer, right? See, so or to legal departments and committees that are set up for these things that are responsible for intellectual property. So these are the companies that you would then give the forms to. So let me give you examples of such companies, right? So examples of such companies here would be the Ghana IP network, right? And again, they exist. It's a network of professionals in Ghana that focuses on IP and innovation, right? They provide resources and support for innovators and inventors, right? Now, that company is this. You've got the likes of Mesty, right? Mesty, for example, also looks at innovation. You've got the likes of CSIR. They also look at research, so you need to speak to them. If you're in the research space, then you need to do your IP protection for your research concept. They are the people that you need to speak to. The Registrar General of Information, I think they also do that IP registration, so you need to speak to them, you know, for your logos and all of these other things. Then you look at the Ghana National Commission for UNESCO. They also help you with IP-related matters and innovation support. And then naturally, other government agencies, like I talked about previously, MESTI, you can, you know, if you're into agriculture, you can find out from NEIP and all of these other organizations how to go about getting your IP. So typical example of an IP process here, right, or declaring your process is looking at the Texas A&M engineering station, right? If you look at the bottom, it tells you that when you're in the stage of discovery and then disclosing when you file the disclosure form and evaluation, your idea is not protected, okay? Because you've just filed it, they've not come back to you and saying, yes, you own it or you don't own it, because they themselves need to check who owns it, right? See, so just because you discovered something doesn't mean that you own it, right? Just because you've discovered something doesn't mean you're protected, because it means somebody else can come and take it from you easily, right? Easily. So you need to ensure that in that discovery stage, you're moving up to the next level as quickly as possible in order for you to then be able to protect it. So in the stage of evaluation, invention of disclosure field, whatever field you're in, and then also your discovery, you will find that you do not own it, you're not protected. So bear that in mind. Then we move to the second stage of where you know, are protected, again, in the publishing space, the patent application filed, and then the patent issues that might come around, and you know, partnering, from marketing to partnering, all of these is now they're protecting idea as you go along, right? Then we moved on to the top where we talk about patent issues and then commercialization. So your licensing, your new venture sponsored by government or research organizations and stuff. Now, if you get a license, that means you own the rights to do what you want to do with it, right? If it's a new venture that you're trying to commercialize, ideally, you should be protected. So when you look at this right now, you need to look at this and identify where you are in your business, whether you are at the discovery stage or you are at the commercial stage. Because if you're at the discovery stage, why are you still there? Why are you pumping so much money into the discovery stage when you can move to the level where it says marketing and partnering, right? So the levels at the top that moves away and says protection pending, you can talk to them. You don't not necessarily have to be at the bottom. So you can also talk to them and then they will help you. So basically, remember, you need to ensure that you're moving from the unprotected to the protected as quickly as possible. So talk to the agencies that you need to speak to for that to happen. Then, in summary, remember that the choice of tools and methods for disclosing your invention or innovation should align with your specific goals, right? The level of confidence that you have, or the level of confidence is required, and the nature of your innovation. Why is this important? Well, now, you have to make sure that your goals align, right? So specifically what you're trying to do. If you say that you are trying to get 20 women into football, for example, right? Now, the video content that you're going to shoot, the branding, the imaging, and everything else has to align itself with the specific goal that you have. If it doesn't, don't do it. If it doesn't, then ensure that you do it the right way. Otherwise, you might have a situation where, you know, you go and choose a tool that does not align with your specific goals, then that will make sure that things take a long period of time for it to happen. And last but not least, it says it's advisable to seek legal counsel and professional advice when handling sensitive intellectual property matters, right? See, so if it's really, really serious, you have to get lawyers and legal practitioners involved in order for this to happen. So with that said, I will end here and then ask you, do you have any questions?
Hello?
Yes. Yes, I can
Hello?
hear you now.
This question, when I finished my undergraduate degree
Sorry,
in chemistry,
your
I
line,
did, but,
your line is breaking. So if
okay. But please, can you hear me?
Yeah, I can hear you now. Go on.
Yes. I'm saying that my first degree that I did in chemistry, during my project work, I published how do you call it, findings in Pakistan Journal of Nutrition. But when I was doing the publication, one of my lecturers said that he won't be part of it, so we added his name to it. So if I want to get intellectual property of this and maybe further progress and do analysis of them, do I have to still add my, how do you call it, my lecturer who was part of it, or I can just go ahead and then just continue with the publications in the other findings that I want to do?
Okay, thank you. So this publication that you want to publish right now is still the same old findings that you had before, right?
The funding, or how do you call it, the pharmaceutical industry, but I have to upgrade it and maybe add on to it, because the findings said that the particular extract from the plant is very potent for treatment of candidiasis. So I have to go forward to develop that particular active ingredient that is in that plant just to come out with a drug. So that's the stage you got to. So I have to develop it into the drug, because the finding shows that it's very potent as compared to the drug in the market. So I have to go further to develop into the, how do you call it, production of the particular medicine. So in this case, if I want to go ahead and maybe do the finding and do the research, do I have to add my lecturer to it, or I have to go solo?
Okay, good question. So yes or no. So what you need to do is you first need to inform the lecturer on what it is that you intend to do, right? And give them the option to either be part of it this time round, but they need to invest in it, or they would then waive their rights to any future publication in relation to this particular new stage that you're going in, because they can always argue that you are using version 1 to go and do version 2, and they didn't know anything about it, right? So you need to inform them that we've done version 1, I'm going to do version 2. Are you interested in being part of version 2? If it's a yes, then it comes with, let's say, $50,000 worth of investment in order for you to be able to be part. If they say, then I can't afford it, so I waive on my rights to be credited and everything else, then you can move away from them. But I would say, do not take my word for it. Seek legal guidance before you move on to the next stage, because if you're going to develop medicines in that sense, that tells me that you're looking at a mass market. You're going to produce this on a mass scale, and there's potential millions and everything else involved. So you don't want the person to come and sue you so quickly. So seek legal guidance on it and legal counsel on it, and then make a next move. But I would definitely say speak to them, get their concern that they don't want to be part, and then you can move on. And if they want to be part, they have to invest X in order for them to be able to be part. I hope that answered your question. Okay, whilst we wait, any other questions?
Yes, please. There's a question in the chat. It says, what advice will you give startups who may not have the time or funds to pursue legal actions against people who steal their IP?
That already tells me, the question itself tells me the answer, right? Because if you don't have the time, then you're not going to chase it. If you don't have the funds, you're not going to be able to do it. So what you then need to do is as sad as it sounds, let it go, because there's nothing else that you can do. Now, how do they end up stealing your IP? They cannot steal an IP. If you have the IP and you have the rights to it and it's registered to you, then they can't steal it. Do not assume that just because you had the logo and you put it out there first, right, means that you own it. No, you're the first to use it. But when we go to Register General to find out, you don't own it. See, so go to Register General and find out how much it costs. And sometimes you'll probably be surprised. It's not as expensive as you think it is. Some companies charge dollars to do these services for you, but if you don't have money, you have time, right? If you have time, go to Register General, speak to them, find out questions before anything else. See, so if you don't have money, please try and find the time to do that. But nobody can steal your IP if you actually have rights to the IP. Nee, I hope that I answered your question.
Okay, can I ask a question?
Yes.
So I want to find out, is it possible to register an IP, say you're registering a logo or some artwork related to your business, but it's not your original symbol, it's like an Adinkra symbol, which technically is like a cultural symbol, it doesn't exactly belong to you. But let's assume that you popularized that symbol. Can you register it as yours?
No, because culturally it belongs to a cultural group, so you cannot. However, if it's exactly the same, so let's say when you look at the Jiname symbol, for example, if you use the Jiname for itself, the way it looks like, then you don't own it. But if you probably added a tint of it, the two symbols in the middle, you maybe turn into a spear or anything. What you've done is you've altered that logo. So now it becomes something new of what it was in the past. That you can own. But then the original Jiname itself, no, you can't own it because it already belongs to a particular group of people. And God willing, they actually have the rights for it. I hear that a European company actually owns the rights to the Adinkra symbols. I don't know how true that is, but I hear that some company has the IP rights to all those symbols, and we currently as a nation trying to fight to get that IP back. So in that regard, you can't yeah, so in that regards, you can't use it, but if you tweaked it a little bit, then you can use it. I hope that answers your question.
Yes, yes, it does. Thank you.
You're welcome. And those of you, always make sure that you get a documented conversations, right, with whoever you're dealing with. Don't just make it verbal, because again, he said this, I said that, don't mean anything in court, really. Was it documented? Even if it's a WhatsApp chat that you had with the person, keep that WhatsApp chat, right? These are the times that I will advise you to screenshot stuff. Any other time, please don't. But in this particular moment, these are the times that I would say, yes, screenshot whatever messages that you have in relation to your business discussions that you're having with your partners and potential collaborators that you might have. So make sure that it's not only verbal, that it's always documented, please. Otherwise, you have a regret.
Yeah, hi, it's me again. A follow up on that question. So, like on what you just said. So, you know, like for most ideas are like most people probably have like the same ideas and probably are collaborating with someone who may also be working on the same idea, but probably hasn't.
So, Master,
gotten to the level you've gotten to.
Telling us what to do. I'm not telling you what you want. No, I said I'm not telling you what to do. Now you see, now you have maybe drafted my class. Like I'm saying.
There's a lot of action going on. Yes, Nee, go on.
Yeah. So my point is like
I'm not keep my last tweet because I've had experience.
Assuming you are discussing your business with somebody, with a possible collaborator and an investor, who probably has started doing something or is planning to do something similar to yours. How do you, and then you later find out that they've actually are implementing some of the strategies that you discussed. In this case, even though you share documents and stuff like that, if assuming they had already started something similar before you had a discussion, how do you prove that it is your probably like certain strategies you shared about them that they are implementing in their business now? How do you prove that, and how do you protect some of these strategies that may have been originally your idea?
Okay, so great question, and thanks for that, Nee. So basically, since they've already started the idea, you also have a similar idea. But then when you came together, the strategies that you shared with them becomes new to them because that's new information that they didn't have before. So you document it, right? This is where you sign the NDAs, non-disclosure agreements and stuff, right? You sign NDAs that say that I discuss A, B, C, and D with you to do these particular strategies in order for you to achieve this and that, right? You need to sign that you are not going to disclose that with anybody. You're not going to tell that and turn into a commercial product, blah, 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 without my consent. They have to sign it. So before you even share openly share all your ideas with people that potentially can be competitors, kindly sign an NDA first before anything else. Does that answer your question?
Yeah, it does well, but to be honest, I don't know how practical it is signing NDA with possible collaborators, because I feel in most cases it'll probably be a turn off for them to even want to engage you in the first place.
But then that already tells you if somebody wants to pull one over you, they will be upset, right? But in business, we have to sign contracts. And the contract says that in order for me and you to engage, we have to protect each other, because that's what it is. It's just saying that I am good, I know you're good, but just in case the demon in us decides to show, we are protected. That's all it is. See, so if the person decides that, oh no, I'm not signing any contract with you, that means the person was intending to overdo you anyway. That's the reason why. See, so do not let that be a reason why you don't sign a contract. Now you got people that can record messages, but that in itself is illegal because you can't record a message without a person's authorization. So the best way to do it is to get them to what they call it, agree by signing an NDA, or you can do what we just did on Zoom. Record your messages. So you only talk to them via Zoom. You don't do any physical meetings. Every single meeting that you do with them is via Zoom or what do you call it? Google Meet and Microsoft Teams, because you can record those conversations. And if that's the case, then after you record it, it transcribes and everybody's good. So make sure that you do not engage people because of their feelings, how they're going to feel about it. Let me ask you a question. How are you going to feel about it if you gave me all your strategies and then I walked off and became a millionaire? I'm sure you'll feel bad about it, right? See, so don't think about their feelings. Think about your feelings too in this regard. Did that answer your question?
Yes, please. Very, very clearly. Thank you.
You're welcome. And thanks for asking the questions. I appreciate that.
Hello, sir.
Yes.
Yes, please. Latif here again. I'm hiring a caterer to take care of my restaurant, and then I wanted to find out. I've developed a contract for us to sign, but as we speak, we are agreeing on how do you call it, how much I should pay her. But looking at the market now, we don't know how much it will give us at the end of the month. So I gave an option: either we wait for us to do 1 month to see how much will come in, then the income, how do you call it, the profit, we'll divide it into 3. I give her 1, then we use 1 for the how do you call it, for in case there's any damage at the restaurant, we can use to pay, and then the one will come to the business. And then the other one is that I pay her a particular amount of money at the end of the month. But looking at the situation, I can't tell her that this amount of money I'm going to pay her. That's the agreement we had before I employ her. So in this case, can I go ahead and sign a contract so that I'll say that maybe at the end of the month, we see how much will come. Then I know that I can pay maybe 2,000 or 3,000. a month, or we go by the first option whereby I divide the money to 3 and give it an option in that regard, because I use that one in my barber salon and that of how do you call it, hairdressing salon as well. So I want to find out from you whether it's in the right way or you have any.
Okay, so one of the best ways to do it is give them a sales and commission contract, right? So you give them a basic bottom line amount. So let's say you cap it at 700 cedis, right? Every month. However, if we make revenue and after revenue and everything else over, let's say 10,000 Ghana cedis, we then increase your wage to 1,500, right? So they know, and you also know that at the worst case scenario, you are going to give them 500 cedis. At the worst case scenario, you're going to give them 500 cedis, okay? Now, if they sell to the agreed amount, then you give them the X percentage that you said you're going to give them. So that X percentage is a commission that is linked to the amount that they achieve. So if you achieve 10,000 cedis in sales, we will give you 10% of that, right? So naturally, then that's also plus your normal salary that you get. So this way, they will end up getting 1,700 or whatever, that's fine. If then the following month, they then sell to 20,000, if you go to 20,000, they will give you 5% of that amount. So that's 5% of 20,000. If you then go above, let's say 20,000 to the 50,000, we'll give you 1% of that amount. So you're putting figures in place to ensure that at the basic level, whether she sells or she doesn't sell, she's going to make 700 Ghana cedis flat. And then if they sell above a certain amount, then they get commission on that. That is the only way I can advise you to do it. Why? Because the person is motivated enough to know that, okay, at the end of the month, I will still get my pay anyway, right? If I make more money, I make more money. That also protects you to be able to budget yourself and say, you know what, I'm going to put 7,000 cedis in the bank to pay this person for the rest of the year. Even if we don't make money, it allows you to be able to do what? Budget for their salary. What you don't want is today I pay you, tomorrow I don't pay you. I pay you this, I don't pay you that. And then you're just messing up your budgets and everything else. So have a flat basic wage or rate that you pay them, and then agree a commissional percentage with them so that when they go over that particular base, you are then able to then pay them more. Did that answer your question?
So very perfect. Is there any way we can get your contacts in case you want to do something? We can do the contract and share with you. Then you can do a review for us in that regards. Is it possible?
Yeah, I'm putting my email address in the chat box now. Yeah, I'll put my email address there.
I appreciate your answer. Thank you.
You're welcome.
Hi, Josiah. I think
there's a contribution in the group.
yes, there's a contribution in the group.
Yeah, talking about
okay, so a contribution.
Yeah, so you need to let the person know that your meeting is also recorded and is given their consent and then agreed. Then that's it. So yeah, same way, to video somebody, you need their permission. Same way to record somebody, you need their permission. On Zoom as well, you need their permission. But then again, it helps because the person knows that they've been recorded and everybody agreed and you're good to go that way. So thanks for that contribution, Leona.
I wanted to add that I think Emmanuel Waji actually raised up his hands. Emmanuel, are you still in the chat? Do you have a question?
Yes, please, I'm here. This is Emmanuel. Hello?
Yeah, Emmanuel.
Oh, okay. I raised my hand due to the question my previous brother just asked with regards to contracting with someone he's employing. And I'd actually wanted to know what kind of employment status he's giving to the person. That how he intends to make that status affect the salary he intends to give the person, because you are doing a startup and you are straight ahead telling someone that someone you're employing that you'll be giving the person a third of your profit. I think is that you being able to start up a business as an entrepreneur means that you surveyed the market. You know that the market is going to yield you. So that should even help you to make or estimate a base profit for yourself. So out of the estimated base profit, you can say, okay, this is my estimated base profit. And even for the first 3, 4, 5, or 6 months, I can pay my workers. And if I don't earn profit myself and still have the business running in the first 6 months, I am okay. Then you can decide yourself how much you are going to pay your employees. So that was what I wanted to contribute. Thank you.
Sir, hello.
Yeah.
I think I did mention that, when if I don't know whether he owns a business or something of that sort. Like this form of way we pay people. As this is the one I mentioned that you have to buy your money to 3. When you go to most of the barbering salon, hairdressing salon, that's what we do. And it's based on what you have, the research you have done, and then you know what comes out of it. And that's what we go by it. So this is not something that just comes as a result of just want to pray. You just want to come something from your head, but it's a lay down process that we tend to use in this industry. So that's why I mentioned that I can bring this way to the restaurant as well, because this person is hardworking, and I've seen her work somewhere. That's what I was trying to give her that offer. But I think what you said, I think I have to just give her an amount. Then later, when the business goes up, I can give an incentive just as a means of encouraging her to do more in terms of commission base. Because I was formerly head of sales and marketing at the business at that time, so we encourage the workers in terms of adding commission to their main salary. So those who do very well, you see that those people who want to work hard and get more money, they work extra hard and overhit their target and get their commission addition to their salary. So I'm pretty well aware in terms of the space. Thank you.
Okay. Latif, okay, I understand you. That's the reason why I was asking, what will the status of the person be in your business? Is the person going to be the chef? And with early startup restaurants, the chefs usually become the general managers even in your absence. Yeah, so that's the reason I was asking if of the status of the person and how that's going to affect your decision of pricing the salary or commission you want to give the person. Thank you.
Any more questions? And thank you for the contributions, guys. It's really good, because then other people also listen in the background. So hopefully they learn something from that. Okay, so if you don't have any questions, we have next Tuesday and next Thursday to continue this cycle. And I think the next Tuesday's class will look at evaluation, and then obviously building a prototype, that side of things. So I'm looking forward to that. And those of you that registered already, we will send out the info so that you will know the times and everything else. Kindly share the link with other people that need or might need this information, because I believe that, again, these information are things that startups need to know. And I'm going to say it here and again for people to hear and listen to what I say. Do not assume that just because you've put a product out on the market, you own the intellectual property. It does not work like that. You have to go and register it, right? You have to go and register it. Now, I wanted to make a statement, but if I make the statement, my team will sue me for it, so I can't make the statement. But you have to look at it in this way. You own a product. You put it in the market. Yes, everybody knows that you put it in the market, but you don't own the copyright, you don't own logos, you don't own anything in relation to that product. Somebody can just go and then own it just like that. So before you disclose it publicly, make sure you own the intellectual property to it. Make sure before you disclose the thing in the public, make sure you own the rights to it. If you want to do it internally, then get your team to sign NDAs, get your partners to sign NDAs. So you see the difference between the two, right? NDAs are internal documents that you sign with your partners and your stakeholders and everything else. That's easy. Intellectual property, on the other hand, that is the contract that you sign with the general public. Because again, you can't be signing NDAs with any and every citizen that there is in the world, right? But your IP protects you. So look at the two in that way. If I don't have money and I'm not coming out in public, let me just move towards the NDA space where I own the logo, I own certain watermarks on my image and everything else. And then I'm getting my partners to sign contracts. But then when I need to go public, then I need to ensure that I own the intellectual property. Copyright here lasts for 75 years. Do you understand what 75 years means? That means that your generation and generations will benefit from an idea that you just came up with and establish a business. So ensure, make it a priority to ensure that you get the intellectual property rights to any idea or product or service that you are rendering at the moment. So if you don't have any other questions, I think they want to take pictures. The moderator will want to take pictures to show our project partners that people actually showed up. So yes, over to you, Olivia. I'll stop sharing now.
All right, thank you so much for this very engaging, very informative, and very great session. I noticed that Leonie had raised up her hand. Leonie, I'd like to give you about 1 minute to give your questions or any contribution, just 1 minute quickly.
Okay, thank you so much. So I know you have probably covered this particular question I'm about to ask maybe in the first sessions, but I missed them. But I just wanted to quickly ask this. So in coming up with a tech product, right? I was approached.
Okay, I think, Leona, you've muted yourself.
Oh, sorry. Okay, thank you so much. So over like the course of the year, I think 2-3 years, we have developed this we're literally like in the research stage. We've developed it to some point, and in between I have had to give more into the research of these particular tech products and the owner as well. So I would call him like the major stakeholder. Now the two of us literally have a balance of information in which we have put into the project. And we have not signed NDAs yet. We have not had any written agreements, which I know is wrong. But because of the fact that we started off without these agreements, I am in between. I'm not sure which foot first I should put. I have stalled with having to do a whole lot of documentations concerning, the product, but I do not know what should come first. Should I first of all approach him with, okay, we've been with, this product throughout these years, we've had contributions. I have voice notes saved. I have other products saved, and we haven't even spoken about like finances and all, but he vocally said he would like me to be a stakeholder, a major stakeholder in the business or in the product. And he has also further made known that he wants to transfer from being a product only, which is a software app, to become a company. So I'm having to build both and be like a project and operations manager for both. But I do not know what first step I should, to be able to revert back to the actual ways I was supposed to have handled the project. So what do I do first? That's literally what I would like to ask.
Oh. Okay. So what is done. What you need to do next is go draft a contract of rules of engagement that is going to be legally binding between you and this person to ensure that everything that you said is going to happen in future is going to happen in future. So if you're going to form a company, what does that mean? What rights you have in the company both ways? You've invested both time and money in it and all of those. You need to have a contract. And what I'm about to say sounds off, but I need to use that in order for you to understand. Human nature, we get married without talking about divorce, or how are we going to get divorced if it actually happens? It doesn't mean that it's going to happen, but we need to have that conversation. Why is that? So that you would know that in the eventuality of a divorce, this is how me and the person are going to do what? Work. It's a founders agreement. You can have founders agreements. All of these documents that says that you do this, I do that. You are liable for this, I'm liable for that, I'm committed to A, B, C, and D. It's just a founders agreement document. I'm happy to help you draft one if you want, but talk about it first. You should have done that before, but you didn't. But your next move should be you getting a founders agreement with the particular person and then saying that these are the terms and conditions. What do you think? If they were trying to pull the wool or the carpet underneath, problem. If they knew that they wanted to work with you forever and ever, signing a contract doesn't really mean anything. They will sign it anyway. See, so anybody that has a problem signing a contract with you usually means that they're trying to do something, to you in that sense. So you have to go and ensure, because listen, right now, you two have, I wouldn't say you have too much money to invest in the business. You're using your skills. So because you're not quantifying the skills, you think it's a play. Right? I do this, you do that. Oh, and you're here. You let somebody come and say, oh, for this idea, I would really put 5 million into this idea. One of you will snake each other. So to make sure that doesn't happen, please sign a contract. That should be your next move before anything else. I hope that answered your question.
Yes, it does. Thank you so much.
You're welcome.
Okay, so with Leonie's question, we close this session today. Just a quick reminder, this session is going to happen again for the next 3 weeks. So we'll be back again on Tuesday next week. We'll send you reminders and the link to the session. Kindly turn on your cameras and let's take a quick picture and then close the session. So please turn on your camera, everybody. Erica, Michael, Gamali, David, Nabo, and John, Abdulatif, Ifwa, Sham, Leonie, Akisha, Victor. Let's see your faces. Let's all turn on our cameras. Erica, we're waiting for you. Victor, we're waiting for you. Gamali, Abdul, Sham, Neon, John, we're waiting for everybody here so that we can just quickly end the session. Lovely smile, David. Kindly turn on your camera, please. Everybody.
Sorry, my face is not available,
Okay,
but you have my name, so yeah.
That's fine. That's okay. Sometimes it happens. Okay. I think we can take the picture. Media team, let us know when you've taken it. Please don't turn off your cameras yet. I will tell you when we can. So, media team, please, over to you. Are we done? Media team, let us know when we are done. All right. So thank you very much for today. Please stand by for the link, and until we meet again, have a wonderful, wonderful day. Bye bye, everybody. Bye.
You have a good